Can I welcome you? And when I say you, I mean the representatives, the other observers, and those members of the inquiry team who are with me in person. I would, of course, have preferred that this meeting was a meeting in person rather than a remote meeting. But as you will understand, the priority of the inquiry is to protect the health of those who are involved and to restrict the spread of COVID-19. We will hope to proceed when we can to more direct meetings, but we anticipate that we will not be able to do that immediately. Now, we have a significant number of individual core participants, and I'm aware that many of them are observing this morning. These are the representatives of children who were treated in the Queen Elizabeth, and also individuals in their own right. They're represented by Mr. Patrick Maguire, who is one of the representatives with us this morning. In addition, there are 11 corporate core participants. The names of all the core participants who have given permission to their names to appear on the inquiry website are on the website and can be consulted there. Now, also on the inquiry website, you will have seen the names of the inquiry secretary and senior counsel to the inquiry, Mr. Alistair Duncan. Now, you've seen their photographs, and can I introduce Alistair Duncan, QC, and David Anderson. The purpose of this morning's meeting is to report on progress, to give you some indication of our plans, and we have invited questions. Now, as far as progress is concerned, the inquiry team is now nearly complete. We have begun investigations. We've made requests for documentary evidence and have approached potential witnesses. The process of interviewing witnesses began earlier this week. We are in the process, we're not quite there yet, but we're in the process of finalizing the arrangements for the lease of office premises in the centre of Edinburgh, which are very conveniently located for transport links within 5 minutes of Waverley Station. Now, in doing what we've done so far, we've been very grateful for the assistance we've had from the representatives of the core participants. I see that as a good indication for the future of the inquiry going forward. The inquiry, as you all know, is an inquisitorial process, but I would like to see it also as a collaborative process. The inquiry is looking for the help of the core participants, and we are receiving that. Equally, if we can do anything to help core participants in their participation, in their helping us, we want to do that. Now, the priority that I have decided for the work of the inquiry is the experience of the affected parents and families in both the Glasgow and Edinburgh hospitals, with the particular focus on term of reference 8. That will be the topic of the hearings which are fixed to begin on the 20th of September of this year. I'll shortly invite Counsel to the inquiry to say more about the planning of these hearings. We're in the process of developing a procedural framework for the September hearings and the work of the inquiry more generally. What I propose is a hierarchy of directions on specific issues, protocols, and perhaps also written guidance. There are already some of our protocols on the website. We have 2 directions in draft form, which I propose should be circulated for comment by core participants in the course of the next week or two. Before handing over to Counsel, can I say just a little about how we intend to proceed in relation to this year's hearings? As I say, we've given a priority to the effect on patients, on families, although in parallel to that, we are beginning our investigation of the other topics which we require to address if we're to fulfill the terms of reference. My intention is that as much as possible will be done on a voluntary basis. As you're aware, the inquiry has certain statutory powers, but I would hope that it will not always be necessary to use these. We've fixed provisional dates for hearings beyond the September 2021 hearings, and we've given thought to the topics that we will deal with in that series of hearings. The precise scope of these topics has yet to be determined, and that will rather depend on the results of our investigations. However, my intention is that as soon as we've begun to make decisions, as soon as we've begun to identify areas that we're concentrating on, we intend to share that information with core participants on a continuing basis. Now, I will now hand over to Counsel to the inquiry for his explanation of his plans for the year.
Thank you, Lord Brodie. Good morning, everyone. In keeping with the invitation from Lord Brodie, I would like to begin by saying something about the hearings in September of this year. As you know, the inquiry requires to investigate issues to do with the construction of the hospital in Glasgow and in Edinburgh, insofar as those issues had the potential to impact adversely upon patient safety. As part of this, the inquiry requires to investigate the effect that these issues had upon upon the patients, be that physical, emotional, or other effects. And the inquiry also requires to investigate the adequacy and the effectiveness of communication with patients. In the hearing in September, we will hear from patients and from families on these matters. The hearing will be their opportunity to tell the inquiry how, in their view, the issues just mentioned impacted upon them and their loved ones. And it will be their opportunity to provide their perception of the way that the hospitals communicated with them. And so the sole purpose of the hearing in September is to hear and to record the evidence of the patients and families on these matters. Their stories will be our starting point for the rest of our work in the inquiry, and it will be in future hearings that we hear from other core participants on the areas covered in the September hearings. There are 4 counsel appointed to the Scottish Hospital Inquiry, and I'm assisted by John McGregor QC, Ross McClelland and Victoria Arnott. The September hearing will be handled by Victoria and me, and preparation for the hearing is being led by Samantha Rory, Deputy Solicitor to the inquiry. Whether in relation to September or more broadly, I cannot emphasise enough what Lord Brodie has said about collaboration, and I would encourage all core participant counsel to get in touch with me should they wish to do so. I am pleased that a substantial number of you have done so already. Many of you have asked for an indication of what lies ahead. As Lord Brodie has explained, our analysis on that continues. Our principal task as counsel at present is the development of statements of issues in relation to the various matters to be covered by the inquiry. From these, we would hope to develop narratives that we will be able to share for comment. That is something that I would hope to be able to tell you about in the coming weeks and months. Thank you.
Thank you, Alistair. Now, we have, we invited questions, and we have questions from I think Mr. McBrearty on behalf of Mott MacDonald. Now, could I invite Mr. McBrearty to ask his questions?
I wonder if your lordship would bear with me just a moment while I just check. I wonder if I just check with those instructing me about the questions.
Certainly, yes.
With apologies for that, my lord. The first question on behalf of Mott MacDonald is the inquiry now able to confirm the position regarding opening statements, and if so, if those are to take place, and if so, when?
I indicated that we have 2 draft directions which will be circulated. One of these draft directions is specifically addressed at opening statements. Parties or participants will have the opportunity to comment on these, and some comments will be considered and a final direction issued. Now that process might be completed in the next 4 or 5 weeks. So there'll be a clear inquiry direction on whether opening statements will be requested. I think you have other questions.
Continue with the remaining questions, my lord.
By all means, Mr. McBrearty. Yes, please.
Thank you. The second question is, can the inquiry confirm who will be expected to attend the September hearings? It was indicated that counsel for some core participants may not be required, and it would be helpful to know whether that is still the case.
The position is, I don't think the inquiry would require representatives of any particular core participant to attend any particular diet of hearings. I mean, we appreciate that some diets of hearings are going to be of more interest to some of the core participants than others, and there will be the inquiry wouldn't draw any inferences against a party who did not attend a particular diet. And what we propose is, administratively, is that we will invite parties core participants who do wish to attend a particular diet to make an application to that effect. It also occurs to me that some parties may wish to attend but not necessarily be represented by their lead counsel. We are very conscious of the need which will be recognized by everyone, to not incur unnecessary expenses. So the short answer is we will not require anyone to attend. We will invite applications for attendance, and as I say, there's no inference to be drawn against anyone who understandably chooses not to attend a particular diet.
Thank you, my lord. The third question from Malt MacDonald is, in respect of document requests, is the most recent request intended to be one of a number of requests for information, or will any future requests be follow-ups to a core participant's initial response?
Our approach is that we're reserving an entitlement to make a series of requests and not limit ourselves to follow-up. I haven't been involved in this directly, but my understanding is that communications have been quite effective. Well, that's our perspective at least, and if we're wrong about that, we will want to be told about that. But the fact that a particular request has been made would not prevent a further request for further sorts of documents later. We would hope to be pretty specific in what we're looking for on the occasion of a specific request. And clearly what we want to avoid from our perspective is, as it were, a large dump of documents on one occasion. But equally, we recognize that those who have documents will require time to organize them in order to provide us with these documents in an orderly way. But the fact that there has been one request does not exclude the possibility of subsequent, a series of requests.
Thank you, my lord. Final question for Mott MacDonald is, can the inquiry provide any further information regarding the substantive hearings to take place in 2022?
Yes, I think I can. The plan at the moment is, which we're in the course of developing, is that we will aim to be able to bring to hearings in the early part of next year issues relating to the Royal Hospital for Children and Young Persons and the Department of Clinical Neurosciences, the Edinburgh Hospital, as I say, in the early part of next year, addressing term of reference 1, 2, 3, and 6, or at least some of these. So following on the hearings in relation to the experience of families both in Glasgow and Edinburgh, the next topic in broad terms will be the Edinburgh Hospital. John McGregor QC will be leading on that, and as we go through the year, as I've already said, the plan will be to share our thinking with core participants as our thinking crystallizes.
Thank you, my lord. That's all of the
Any
questions for a
questions?
moment on. Appreciate it.
Now, do any of the other representatives of core participants have a question at this stage? I think I have to, if you do, I think and I say this apologetically, have to ask you to put your hand up. I'm looking at the screens. There may or may not be questions, but if anyone wishes to ask a question, I'm very happy to attempt to answer it. Right, everyone seems... Mr. Maguire.
Thank you, and I'm very grateful to you for setting out the patient-focused approach that you're taking in the initial approach, at the very least. One question that has occurred to me, having heard all that you have to say, my lord, and the question from Mr. McBrearty is term of reference 4. I anticipate that the inquiry seems to be approaching matters in a fairly sequential. Tranches of evidence will look, or certainly focus, on particular terms of reference. My question therefore is, currently, what is the thinking in relation to term of reference 4 it is, as well as term of reference 8 and indeed others, a very important one to those that I represent, and would it therefore be the intention for that to be caught up among other tranches of evidence, or would there be any intention for that to form a tranche of evidence in itself?
Well, as you'll have gathered, Mr. Maguire, well, first of all, the first thing you will have gathered is that I had to turn up term of reference 4 because although I have read, reread and read again the terms of reference, I don't have them in my head. Now, term of reference 4 is directed to a number of matters: deliberate concealment, failures to disclose wrongdoing, and whether disclosures were encouraged, including the implementation of whistleblowing policies. Now, these, as I say, a number of topics there. My initial impression is that these are themes that are that interweave with other terms of reference. I would have thought it unlikely to feature as a topic in itself, but that might very well come to depend on judgment of counsel as to how they see the narrative in the inquiry. There's no question but we must address the matters raised in terms of reference 4, but how it will best fit from the practicalities of leading evidence and, as I say, from in narrative terms, how it fits in with investigating the story that the inquiry must investigate. I'm not sure. Now, that's not a very precise answer, but I think you anticipated in your question, Mr. Maguire, that you might not get a very precise answer.
That would be a fair comment. And I'm obliged for your answer.
Now, does anyone else have anything they wish to raise with us? As I hope everyone is aware, the legal team with the inquiry is always open to communication, whether with counsel to the inquiry or with the solicitors. And I would hope that people always feel that picking up the phone or sending an email message will get a response. As you also know, we have a procedural hearing fixed in June, which will address itself perhaps more specifically to the administrative nuts and bolts of how we best carry out the hearings beginning in September. Well, thank you very much for your attendance. Again, thank you for your patience. I repeat the apology for the technology, although, as is no doubt self-evident, I'm not the controller of the technology. But thank you very much for your attendance. And I look forward to working with you in this inquiry. I mean, Alistair underlined this. We see this as a collaborative project, something in which we're looking for all your help. But as far as today is concerned, thank you very much, and goodbye until we see each other again. I hope soon face to face, but it may be virtually for the immediate future. Thank you very much.